Welcome to our Startup Essentials series webinar. Today we have Calvin Leung, who's a partner merging in high growth companies at Osler, Hoskin Harcourt, and he'll be talking to us about incorporation and organization of your company. Just a note here that you could enter your questions in the chat anytime. And Calvin has suggested that he may be able to answer the questions live on the spot, and then there will also be time at the end of the presentation for any additional questions. So please do feel free to put in your questions as the talk continues, and then at the end we'll have a little bit more time. So with that, I'm going to hand it over to Calvin to get us started.
Great, Michael. Thank you very much. So lovely to meet all of you. So today's topic is incorporating an organization of your company. Not all businesses necessarily need to be a corporation. And I want to start off by talking about the other kind of corporate structures that founders and ventures can take before they actually decide to become a company. And once they do decide to become a company, I want to talk about how we set up our companies for success for investors, whether venture-backed or otherwise. Just gonna move forward here, and please ask any questions that you have as we go. So the simplest and easiest form of running a business is the first one is a sole proprietorship, where you don't actually have a separate entity. Think of a lawyer working on his own, or a doctor working on their own, not with a medical clinic or a legal practice, or an independent contractor as well, that has their name, their business, and kind of runs the business on their own. This type of sole proprietorship tends to be at the very early stages if you're not sure whether your business model or your business is supposed to be one that really expands, that it would require the level of a corporation. So it's a lot lighter to manage. It's simple. There's not really a governing statute over it, and there's like a few formalities. So it's really, I want to start something, I'm going to be a sole proprietor. Disadvantages of it, of course, are you are the business. There's not really a separation between you and the business itself, which leads to unlimited personal liability. No one can really invest in you, right? Because it's you as a person. So you have limited ability to raise capital. Okay. So sole proprietorships. We see that often with service people, lawyers, photographers, things like that, or businesses that are really starting out and being tested. For all of the ventures and age well, I'm expecting that no one will really be a sole proprietorship. The next one is partnerships. These ones are very common if you are not the only person in your venture, so not a sole founder. You have two founders, you have three founders, but you tend to be lawyers, you tend to be doctors and things like that, where you don't really need a separate legal entity. You just want to aggregate your forces. You want to be able to work a business together and then share profits in any manner you wish. So it's very similar to a sole proprietorship in the sense that there's unlimited personal liability. It's, again, usually hard to raise capital, but it allows you to run the business as 2 people, 3 people, 4 people, if that's the kind of setup you want. Okay, so it's flexible in that sense. If you have any questions, please feel free. Now, so we spoke about a sole proprietor. I am the business, I'm running something. There's not really a distinction between me and the business itself. I'm adding a partner or two where we want to still have that kind of dynamic where I am the business, but still within just between 2 or 3 people that are working together towards the same intent of an enterprise. A joint venture is another form of business that we do, but we tend to see it more with partners, but partners in the commercial sense. So let's imagine I am a distributor of goods, and I'd like to enter a specific market, and I need a manufacturer to help me do that for whatever reason. Sometimes what we can do is create a joint venture between the two, where we are marketing products and goods and services as a separate enterprise without actually incorporating a new entity. So this is a kind of a flexible contractual way of creating a business between 2 parties without going into the weeds of an entire corporation, which can be quite heavy from a legal perspective. So joint ventures are created by written agreement, could be verbal in certain jurisdictions, and is flexible in that sense. So it tends to be more on a commercial basis for specific projects, I would say, is where we tend to see this. Corporations. Now, this is really the go-to and gold standard if you are in Canada going to be running a business that you expect to scale. So any company that is venture-backed, expecting to receive financing, whether it's debt financing or equity financing through investors, venture VCs, private equity, or others, friends and family as well, will usually end up being in a corporation. Okay? Advantages of a corporation are it is a separate entity. It exists on its own. So you are not the business. So you have limited liability and risk. You can raise capital through debt and equity. You can get investors. That's what investors are used to seeing. If something happens to you, a death or impairment, or you decide you want to stop running the business, it is possible to sell your ownership in the corporation. So there's this succession idea, and it's simple to transfer ownership. You can see that in the list of advantages here we have on the slide. The disadvantages are, of course, that a corporation has a little bit more maintenance to do, ongoing costs from both a legal and accounting perspective. You know, there's formalities, there's a legal statute that applies to set it up. But pretty much most businesses that are going to scale will become a corporation at one point or another if they are not already. And many of our clients decide to start immediately as a corporation. Okay? So it is rare for us to see sole proprietorships, partnerships, and joint ventures for venture capital-based companies or anything that's really expected to scale to a higher level. I'm going to move forward. Now let's talk about businesses. When we have a corporation, they have what is called share capital. And that's what represents the ownership stake you have in the company. You can choose how much share capital you want. It could be 100 shares, it could be 1,000 shares, it can be 1,000,000 shares. What we propose when we are creating the company is that you have about 10 million shares outstanding. And I'll explain why. If you only have 100 shares outstanding and you want to give away 1% of your company, you have to give 1 share. But eventually, as time passes by and your company grows in value, let's say your company is worth $10 million, giving away 1% of your company is quite a lot in value. And you actually start wanting to go to lower numbers, like 0.01%, 0.001%. And that's very hard if you only have 100 shares outstanding. So we do push for a larger share capital. 10 million is really the standard at which we start now, so that then you can partition your ownership over time as it grows into a smaller number and a smaller amount of shares. It creates more flexibility there. If we talk about shares themselves, there are various classes of shares that exist. In a venture-backed company, we are usually going to see common shares and preferred shares. The founders will usually receive common shares. Employees will receive common shares. Investors, quite often we see will receive preferred shares. Okay? And we'll talk a little bit about what are the differences between the two. Common shares have the right to receive a right to vote, a right to dividend, and a right to participate in the economic interests of the company. The voting rights are essentially there to make major decisions for the company that are done at the shareholder level. So let's think of electing your board of directors, and your board of directors then elects your officers of the company. So voting rights on common shares go to governance. Dividends are if ever you want to make a distribution of profits that are in the business. And participation rights are there on the liquidation event. So if ever you sell the company, who gets to participate in that? So 3 main rights for a common share: voting rights, dividend rights, and participation rights in the event usually of a sale. I want to talk about that a little bit. For venture-backed companies, we will usually tend to want to give equity to our employees, give equity to people coming in, advisors, contractors, because at the onset of the company, you don't really have cash to provide to them. You can't remunerate them for their services. And sometimes you're going to want an advisor who can bring a lot of value, who's an expert in their field, and you can't pay them. What happens is you will give them equity in the company. The equity at the time of your company is not worth a lot because your company is not valued at a high amount, but it could be worth a lot in the future. There's a lot of upside, right? So they'll take remuneration in the form of equity. The main concern I often receive from founders is, okay, I'm happy to give some equity, but I don't want them to have a say in my company. That's why we often set up our companies to have two series of shares, so two types of shares, voting common shares and non-voting common shares. So the founders will usually receive voting common shares, and they'll have a say in the governance of the company, whereas employees, advisors, anyone kind of coming in at that stage who receives common shares will receive non-voting common shares. That's how we like to set up our companies and how the standard in the market that we've applied. Non-voting common shares means they don't choose the board, they don't have a say on things except for very specific scenarios. But we give them the dividend right and we give them the participation rights. So in other words, we say, employee, advisor, you can participate economically, but you will not participate from a governance perspective. So we say shares here in Canada, but most of the things you'll see online, if you're reading, kind of following more the world or the US, is you're going to see stock, but it's essentially the same concept.
Calvin?
Yes.
And I think there was a question a little earlier, and I think it was going to be asked verbally. So, Elaine, if you still have that question, could you raise your hand again, just so I can be sure? And then, there you go.
Yeah, of course. Hi, Elaine.
Hi, yes. Actually, I have a question and a comment. Actually, it's because the chat is disabled, so we're not able to write questions in the chat. So that's the first thing. And then I had a question about the legal perspectives of a corporation versus if you're a sole proprietor. Just to make sure that I understand clearly, when you're a corporation, you personally are not legally
liable.
Reachable. Yeah. Okay.
Yeah, that's right. So there's this concept at law which speaks to juridical personality or existence, which essentially means, you, Alin, are a person. You can contract, you can take on liabilities, you can own assets, right? A corporation can also do that. So legally, they have that same existence as a person, as an entity, where they can own assets and they can have liabilities. So the advantage of creating a corporation is that when you are contracting with individuals, when you're hiring employees, when you're taking on liability, when you're taking on debt, it's the corporation that takes it, and you are one level removed from that. So the corporation is the one contracting, taking all the risks, the assets, the liabilities. And you are just a shareholder of the company. In the context of a sole proprietorship, there is no corporation, there's no separate entity. You essentially are the business. And I'm simplifying, but you essentially are the business. And so when you contract, when you buy assets, when you take on liability, you are taking that on personally. Does that answer your question?
Yes, thank you very much.
Okay, no problem. If you have anything else, please do. I want to be as helpful as I can to everyone on the Zoom call here today. So I love questions. So there are no stupid questions, and I'd love to answer them if you guys have any. Okay. I'm going to keep on going here. I think the last thing I want to add here about share capital is the share capital, that ownership right that you get in terms of voting dividends or participation rights, depending on what you decide to give them, is really what allows you to raise capital from an equity perspective, right? So when you're bringing in investors, they can come in various ways, but ultimately, it's by owning shares in your company that they do that. Okay. And I think this kind of summarizes what I said. I'll run through it quickly since we do have a bit of time. Provides the ability for company to raise funds, no obligation to repay, and no commitment to pay dividends. So when people buy equity into your company, they buy common shares, right? They're buying a piece of your company. Let's say your company is valued at $1 million. You have 10 million shares outstanding. You want to give them a 10% ownership stake. So they pay $100,000. Simplifying the math, they're going to receive 1 million shares if you're selling to them. And so that money is now with the company, right? If they were buying from the company. Not an obligation to repay. That money is with the company. Okay. Disadvantages bear in mind that if they are an owner, they are a shareholder in the company, they now have rights. So they have a right to receive financial statements, they have rights to shareholder meetings, they have a right to have a say on certain things. And that's why we try to limit those rights quite often by doing non-voting shares. If they're an investor, they won't accept non-voting shares, they'll have voting shares. But if you're an employee or consultant or advisor, it's important to push the idea of non-voting for them because they're not as involved in the company, they don't really know what's happening, they're not necessarily sophisticated, they may not want to have a say. And so we push for non-voting there, but your investors will ask for voting shares. Bear in mind, obviously, if investors are coming in, you're diluting your ownership of the company, which is part of the coercion norm. I'm going to move on. So here we're outlining a few other advantages and disadvantages. Happy to chat about that more. But the reality is, as soon as you are really thinking of raising capital and bringing on investors, you will need to be a corporation. And there will be things to consider in that regard. And I've highlighted the most important ones for you. There are also going to be advantages to being a shareholder versus not being a shareholder for an investor. Capital gains treatment, which has been going on in the news a lot and has recently increased from 50 to 66% or will be. So there are things to talk about, but there will be other kind of webinars on this that'll be more appropriate for that discussion. So we've spoken about the base of a corporation, which are shareholdings, right? That's the very beginning. Okay, you have a corporation, it's its own legal entity, it has shareholders, people who own it. They are the owners, and they have specific rights. The shareholders are going to elect the board of directors. And as you see here, the directors are the ones that essentially manage the business and have the ultimate power on the day-to-day in terms of high-level decisions. The board can be as big as you want, but it should really only be people there who are going to be actively involved in what's happening and making important decisions. That'll usually be the founders and a lead investor in a financing round. They have to be over 18 years old. It can't be bankrupt. It has to be an individual. And once you are a director, when you are making decisions as a director, when you're acting on the board, you have what's called a fiduciary duty, which means you have to act in the best interest of the corporation. If you breach that obligation, you don't act in the best interest of the corporation, you could be subject to a claim. You could be personally liable. And a director is personally liable for certain things. For instance, unpaid wages for employees. In certain circumstances, if the director was acting negligent, you could be personally responsible. So then that goes to the discussion we were just having. As a shareholder, you're not generally liable for the company and its debts and obligations. There are certain scenarios where if you're really committing a bad act, you could be personally liable, but those are rare. You'd really have to have been doing like something fraudulent. As a director, there are certain circumstances where you can be personally liable. And the best example of that is unpaid taxes and unpaid wages. There are other scenarios, but those are the main ones. if you acted reasonably, if you were careful, if you were not like continuing to employ employees while knowing that your company was going insolvent, usually you're safe. But it's important to know that when you are a director, you have certain obligations and responsibilities, and if you fail to do them, you could be held personally liable. I think that's the main takeaway that I'd like you guys to know. The board of directors is going to elect the officers of the company, and the officers of the company, the president, the CEO, the CFO, the CTO, the vice president, they are the people who run the true day-to-day. They also have fiduciary obligations, and they are designated by the board. So the board will meet, often quarterly, twice a year, 4 times a year, 8 times a year. It depends on the company. They're going to receive a report from the officers, from the president, the CEO, on how things are going, and they make big decisions on large strategy decisions, governance issues, whether we take on big funding, what the budget is of the company, and anything really that the CEO requires feedback from, right? The officers will report to the board of directors on those big level decisions, whereas the officers are going to be really there on the day-to-day, hiring and everything like that, and making and brokering deals. But the officers then tend to work closely with certain board members, as tends to be a team-based approach as opposed to separate interactions, right? So the officers and directors work together to kind of make those decisions in terms of governance. Great. Okay. So I don't see any questions. I'm going to move forward. How do you incorporate a company? Very simple. There's a form that gets filed. If ever you need help with that, we can help you. Otherwise, there are resources available online on the Corporations Canada website to help you with that. It's a simple form where you file, you can choose a numbered company or you can choose a name. And then you put the initial list of directors. And then you can incorporate with that. Once the company is incorporated, as you say, born here, then you have to move on to actually organize the company. So it's not enough just to incorporate. You actually have to do some internal legal paperwork, putting in place the internal governance structure. So who are the shareholders? Who are the directors? Who are the officers, right? When is your fiscal year end? When is your financial year end? What are my bylaws? Okay, so there's a bit of work to be done there internally. And that's why there's additional burden, as we mentioned earlier, to have a corporation, but there are a lot of advantages that come with it too. Okay. So incorporation, there are a few things to consider where you incorporate. The first one is jurisdiction. Where should I incorporate? We often get the question from founders, should I incorporate in Delaware? A lower tax rate. A lot of my clients are going to be in the US. Generally, the answer to that is no. If you are a Canadian founder, you will want to incorporate in Canada, right? Whether federally, at the federal level in terms of a corporation, or provincially. There are a lot of reasons for that, many of them having to do with access to non-dilutive financing with the government, and tax benefits you derive as being a Canadian resident owning a Canadian company. So if you are a Canadian founder, the general rule in 99% of the cases is going to be you should incorporate in Canada, and you should have no issue getting funding from the US or externally. People are very used to funding Canadian companies. Now, on the decision to incorporate at the federal level or the provincial level, the standard is to incorporate at the federal level. The reason being that outside investors are used to and like seeing a Canadian corporation, a federal entity, and across each province, all of the investors, all of the lawyers are used to seeing federal entities. It's our equivalent of a Delaware company. In the US, often you'll incorporate as a Delaware company because all the lawyers in the US, all the investors know Delaware companies. The same is true in Canada for federal entities. The only time we push to incorporate as a provincial entity is if you have a residency issue. And we'll get to that later on. But a federal entity, a Canadian entity, requires that at least 25% of your board be a Canadian resident. So if you have 4 directors, at least 1 out of the 4 directors has to be a resident of Canada. And the other 3 could be non-residents. Certain of our founders will have no Canadian resident, and then it becomes an issue to be a federal entity. Then the question does raise itself, why are you doing a Canadian corporation? Where are you located? And quite often the answer is, well, I plan on moving into Canada. It's a lot of reasons. I haven't moved yet. So then sometimes we will do a provincial entity versus a federal entity, but generally the rule is you should go with a federal entity. That's jurisdiction. And we're going to have separate slides for this. I'm going to move a little quicker here, but governance, board composition, we spoke about a little bit. Founders and reverse vesting is going to be very important. I'll preface the topic a little bit, but essentially, when you are 2-3 people getting together to start a business, lots of things can happen in life. You know, one person may still have their job and want to be doing it part-time. Another person is just finished their PhD and is willing to go through it full-time. And some people want to be completely hands-on, some may be hands-off. You may be starting it with a close contact, and your friend is there and you trust them a lot, but things happen, they go through a divorce, and they decide, I can't continue the business, I plan on moving out of the country, or finally someone gets a promotion in their job and they say, I'd rather continue on this path in my career versus a startup. So a lot can happen with founders at the onset, and so we put what's called reverse vesting arrangement on the shares. We say, we're going to issue you these shares, but if you decide to leave the company, if things happen in your life, then you haven't earned them, and we want to be able to buy them back from you because you should no longer own shares in the company. You should no longer be a founder. Okay, and we'll get into more detail on that, but the general principle there is lots of things happen at the beginning of a business. So we have to set in place a legal framework and structure for a corporation that when those things happen and those occur, the company is agile, it's flexible, and it can adapt to the changing environment of the founder team. Employment and labor is another big part. Equity incentive plans and employee compensation through equity, we spoke about a little. It's going to be hard at the beginning to bring in good talent, and so we often give them equity in the company. And the way we will do that is not through an issuance of shares like we do with the founders. We are going to do option grants, which you may have heard of before, and they bring a lot of benefits and advantages. And the gold standard is when you're granting to employees, you're granting to advisors, consultants, to grant them equity through your equity incentive plan via options, both for them and for the company. Final topic is going to be protection and ownership of IP, which is obviously crucial, especially if you are an IP, intellectual property oriented company, and you have a lot of value there, whether it be in your algorithm as a tech startup, whether it be in your data set, you know, in machine learning AI, or whether it be in your patents, you know, if you are more on the, you know, biomedical medtech side or whatnot. Okay, we're going to move forward. So the jurisdiction slide essentially covered everything we just spoke about. Governance. So best practice is to have an odd number of directors in the event of a disagreement. It's always difficult to make decisions. 1 board member to 3 board members is what we see for early starting company. If you're 2 founders 50-50 and you want to have a 2-person board, we see that quite often, and that's okay. It's easier to have a 2-person board than to try to figure out between 2 founders who should have the higher say if you're 50-50, and it's hard to find a 3rd person. So if you're 50-50, I would suggest that's okay with the 2 board members. We want to avoid directors. Honestly, 1 to 2 at the beginning is what we'll see. When your first investor comes in the lead round, we would see a board of 3. So 2 founders, 1 investor, or perhaps 1 founder, 1 independent director, and 1 investor. We try to strike a balance for good, clean corporate governance practices. Directors have to be high-value contributors. Don't just hand away director seats. These are really people who are going to be very important to determining the direction of your company. So they have to be chosen carefully. I'm just looking at the last bullet here. What percentage of the company do founders individually hold? And what significance does it have for purposes of approving shareholder actions? Do some shareholders have blocking rights over certain actions? If you're a 50-50 shareholding, it's pretty much going to be a scenario where both founders always have to agree with each other. If you are 3 founders of equal weight in your shareholding holdings, so 1/3, 1/3, 1/3, you have to realize that always means 2 out of 3 founders can always decide. Okay? So those are the kind of the questions you have to think about when you're giving equity and when you're choosing the allocation between the founders. So shareholders agreements. The general rule is the majority ownership of shares makes the decision. So in the example where it's 50-50, both founders have to agree because there's a stalemate. Where there are 3 founders and they all own 1/3, you need 2 out of 3 in order to get across that majority threshold. What's important to bear in mind is that in Canada, we have 2 magic threshold numbers. The first one is a majority, so 50% plus 1 vote, majority rule. But we also have a special threshold, a special majority threshold, which is set at 2/3, 66 2/3 to be exact. So having 51% ownership, and this is important for all Canadian founders to know, is not enough. If you really wanted to have full control on most decisions and the majority of decisions, you actually have to be at 66 2/3. You have to be at 2/3 ownership. So 51% is not enough. I'm mentioning this because those are the general rules, and you have to bear them in mind. But we also put in place what's called shareholders agreements between founders. And those shareholders agreements allow us to deviate from the majority rule or the 66 2/3 rule. I'm simplifying things. They are more complicated than that, but I want you to understand broad stroke principles. Broad stroke principles are 50% plus 1, 66 2/3 are the key threshold that you have to be aware of. But in shareholders agreements between the shareholders, you can choose to do other things. You can choose to say it's not the majority that elects the board. Since we are 2 shareholders or 3 shareholders, I want each shareholder to be able to nominate 1 board member. You can do that, right? You can also say, in the event where I want to sell the company, if 2 out of 3 founders agree, I want the 3rd founder to automatically be forced to sell the shares, right? If a founder decides to sell their shares, I want to be able to have the right to purchase those shares from that founder before he sells them to a 3rd party, which is called the right of first refusal. If a founder decides to sell, I want to be able to sell with him. He shouldn't be able to exit on his own. That's called a co-sale right, or piggyback right, or tag-along right. That's lots of ways of calling it. They're all slightly different, but the main idea is always, if someone decides to sell, I want to be able to sell with him. Okay? The drag-along right, just to start giving you guys the verbiage, is the one I discussed where if a certain threshold of shareholders decide they want to sell and they want to force other shareholders to sell, that's called a drag-along right. Okay? The last one I want to mention is the preemptive right, or the right of first offer, is sometimes what it's called. And that's essentially if a company decides to issue more shares. Company says, I need money. I'd like to sell a 10% stake in the company for $100,000. And I have a buyer. The preemptive right, or the right of first offer, is the right of the shareholders to buy those shares first, before anyone else can. So that's a preemptive right. So those 4 rights are probably the biggest rights and the major ones we'll see in the shareholders agreements in terms of your shareholder ownership. A drag-along right, a right of first refusal, a co-sale right, and a preemptive right. We will also see in the shareholders agreements board composition. There are other things we'll see in the shareholders agreements like information rights and registration rights, which are more complicated if your company decides to go public, but those really only tend to come into play once we see investors, all right, in terms of the registration rights. So a lot of things can go in there. I think the take home here is there's a lot we can do in shareholders agreements. You don't have to think about that too much. There's market practices here that we can advise you on for that. I'm going to move forward. I've covered it here. In Canada, the traditional way of doing shareholders agreements was that you would have 1 shareholder agreement. that has all of your rights. Everything I just mentioned would be in one contract. In Canada, in the venture capital space for venture-backed companies, we've moved away from the one contract model, and we have a 3-contract model now. So you have more paper, it's not more complicated, you just have to get used to it. What we have is a voting agreement that essentially has everything to do with the voting rights. So your board and usually your drag are there, your board composition and your drag. So how do you elect the board is going to be in your voting agreement. The ROFR and co-sale agreement is going to be how you sell shares in between each other and when are you allowed to transfer them. And the shareholder rights agreement, sometimes called the investor rights agreement, because often the investors are going to be a party to this one in particular, has everything to do with like special rights in the company. You know, preemptive rights, information rights, registration rights, observer rights on the board, that's going to go there. Now, why did we move towards a 3-contract setup? We moved towards a 3-contract setup because that is what the United States were doing. So the entire venture capital ecosystem out of the US are on these documents. Because what happened was it was very expensive to hire lawyers. It was very expensive to agree on what the rights should be of the shareholders and the investors. So the US moved towards a framework of standardized documents and standardized understanding between founders, law firms, and investors as to what a market approach should be in terms of shareholder rights. Canadian companies receive a lot of investments from the US ecosystem. And so to facilitate the funding from US investors into Canadian companies, the Canadian ecosystem decided to follow the lead as to what they were doing in the US. And we have Canadian versions of these US documents. If you are setting up your company, we strongly advise that you be set up on the venture and you plan on receiving venture money, we strongly advise that you go on these forms of documents. If you are not on these forms of documents right away, you will be put on these forms of documents eventually. As soon as a venture-backed venture capital company comes in, they're going to want to see these. Not only because they're used to them, but because other investors are used to them. It reduces legal costs, it increases the speed of deals closing. It reduces that threshold where you want to get financing in. It just makes things easier from a legal perspective. People know these, they know how they work, they think they're fair. And so you're expected to go on these shareholders agreements. We still see sometimes, particularly I would say in Quebec, companies that are on 1-contract shareholders agreements. And the reason for that, sometimes what the firms say, sometimes the firms are just not aware of these venture-backed forms. And sometimes they prefer to keep it on 1 contract until we receive venture-backed money. We prefer to put our founders directly on these shareholders agreements because it already gets you used to seeing what the terms are. You start getting used to them. And when you have to negotiate with your investors, you have to start understanding what they are going to be asking in the document. You already know what they look like. There's an educational process that happens with our founders, and we like to start them right away. So our philosophy here is to, although they may be slightly more complicated or a little bit heavier at the beginning, they put you in a better place from the get-go. They reduce legal costs down the road, and they put you in a much better place to negotiate your deal terms with your investor. Or else a lot happens when a financing round comes in. You have to learn the shareholders agreements. You have to negotiate your price. You have to figure out the pro forma of your modeling of your round and how much dilution is happening. You have to handle due diligence on your employment contracts. You're going to have to do financial diligence. You're going to have to pitch to other investors to syndicate your round. We try to make sure that not all of this is happening at the same time. So we accompany you in the journey earlier on to get you educated right away and understanding what's happening. And I can't emphasize how much this 3-contract form of shareholders agreement is important for companies that intend to receive venture money. Okay.
And Calvin, there's a question in the chat there. It's basically asking, are these documents and agreements applicable if we are incorporated at the federal and provincial level? So does it? No.
Yes. So you would put these shareholders agreements in place, whether at the federal or the provincial level, and they will be substantially the same. There are slight changes that are made depending on your jurisdiction because the laws are slightly different. But the essence of them is the same, and they will look 98% identical to whether you're provincial or federal. Thank you for the question. Founders and reverse vesting. We recommend that all founders are subject to reverse vesting arrangements. That means we will issue the shares to you. You're going to own them 100% on day one. But if you leave the company, if you're terminated for cause or without cause, we can take them back from you. Standard approach here between founders is to have a 4-year vesting period. And by vesting, we mean vest in terms of ownership where we cannot buy them back from you. 4-year vesting with a 1-year cliff and monthly vesting thereafter. What is a 1-year cliff? 1-year cliff means that nothing vests until the first year anniversary, 365 days. And then monthly vesting thereafter means your shares start to vest pro rata over the next 3 years after your first year cliff. Let's put that in numbers. You have 1 million shares, you take a 4-year vesting period with a 1-year cliff. That means on month 6, nothing has vested. If you leave the company, all your shares can be bought back. On month 8, that's the same thing. On month 11, that's the same rule. On month 13, you are now past the 1-year cliff and 25% will have vested. You are terminated or you decide to leave the company, you will keep 25% of your 1 million. You will keep 250,000 shares. If you leave at month 18, you will keep your 25% ownership, your 250,000 shares, and whatever you've earned up until that date for the 6 months since the initial year passed. So you'd have to run the math, right? You have 750,000 left from your 1 million that have to vest over the remaining 3 years of your 4. You divide that by 36 months, and then you will get the amount that vests on a per month basis. Okay. We put this in place at the onset. It's important to do that. When you have a financing round, we try to argue with the investors that we keep that in place. Sometimes the investors will ask you to refresh your vesting, and then we negotiate essentially how many shares have to become subject to vesting, right? And the philosophy there is, investor, would not have invested in your company if these 2 or 3 founders were not in it. And so I want to make sure you stay in the company and you're motivated to stay in the company. And so I want your shares to vest again. As you can imagine, we have scenarios where you have a 3-person founder team. You don't revest the shares. After 4 years, one founder says, great, I own 20% of the company. I'm going to go do other things as opposed to stay there. So to make sure that it incentivizes them to stay longer, investors will often ask to revest the shares and say, I understand you've already worked 2 years, but I want another 4 years from you. So let's revest again. It doesn't have to be 4 years, it could be 3 years. It doesn't have to be a 1-year cliff, it could be no cliff. That is negotiated, but the philosophy behind it is the investor will want to align your vesting with how long they think is reasonable for them to ask you to stay with the company. Okay. I'm going to keep going here. This is some sample vesting language that we would see. So X amount of shares will be released from the repurchase option, i.e. vesting. They will vest after X cliff date. And then you can see language in terms of the monthly vesting that happens afterwards. I think what's more relevant is this kind of graph at the bottom, which I find helpful. You know, the one in dark red is essentially the number of shares that are subject to vesting, i.e. are subject to repurchase. And then you see that over time that diminishes until eventually none of it is subject to repurchase.
Calvin, Can I ask a question there? Maybe it could be
Absolutely.
relevant for people starting their companies. So when you talk about subject to repurchase, do you have any examples or further comment on what happens in practice for some early stage startups where maybe they haven't even commercialized yet, and a founder is in there, let's say with a 4-year vesting period, and maybe after 13 months they leave with the repurchase option. Is that something that you see teams acting on normally, or is it just typically left where they own those shares, they've moved on, just because of what ends up happening with the repurchasing piece?
Yeah. The repurchase option is pretty much always triggered. So in your example, where someone has been there for 13 months, they've now earned 25%. I would say 99% of the time, the other founders will want to buy back the shares that have not vested. And the founder that's leaving will want to keep their 25%. That's in a good scenario where we feel that founder has contributed and earned it. Now, the reality is, if a founder is leaving after 1 year, our collective experience as a firm is usually it's because things did not go well with that founder. And usually the other founders are going to want to negotiate a buyback of even more than just 75% of the shares, right? Sometimes they can't because that was a deal that was struck. But our experience is, yes, it gets repurchased, Michael, but not only does it get repurchased, sometimes they'll even try to negotiate more. Or the founder that's leaving will say, okay, I'm happy to sell you the remainder of the 25% that I do own for X amount. So usually when a founder leaves in the first year, things did not go well, I guess is what I'm trying to say. The relationship degraded, they weren't doing what they were said. And quite often we get the feeling from founders that they don't feel that they even earned that 25%. I'm being a pessimist, but I think it's important to do so. Sometimes it's okay. Sometimes it goes well, and we negotiate a different amount, and founders leave really happy, and they say, "Fine, I don't need 25%. I'll take 10%." That's in a good case scenario. Does that answer your question, Michael?
Yeah, it does. That's great. I mean, I know it's not uncommon for things like this to happen with new teams, so I thought it's worth commenting on.
Yeah. So having employees tends to happen later on. I would say actually before employees, you will have more independent contractors and advisors, which means they're not actually on the payroll. They don't fall under Employment and Labor Standards Acts. But I think the message here, whether employee or independent contractor, you want to have a written agreement with them that essentially lays out what their roles are, what they're being paid, what kind of equity they're receiving in the company, as well as their intellectual property assignment to the company. So the main things are going to be compensation, IP ownership, and what are the roles and responsibilities of that employee or that independent contractor. When you grant options to an employee, which happens a lot with venture-backed companies, you do it out of an equity incentive plan that you need to have put in place, and the standard rules apply of 4-year vesting, 1-year cliff. That really is the market standard. You see on the slide that we talk about restricted shares, restricted share units. There's other ways of doing that. You see that a lot more in the US for a lot of reasons. Just note that in Canada, it's rare that we issue these, it's rare that we issue these for early stage companies. You are going to be issuing options. They're more beneficial from a tax perspective for the employee is the main reason compared to restricted share and restricted share units. When you're granting an option to an employee or a consultant, you're granting them value, right? Instead of paying them salary, you're giving them an option that has a value. And so anytime you transfer value to someone for services they performed, Revenue Canada, Revenue Quebec will want to tax it. So what options do is that they allow you to defer that taxation. because an option has no value or the underlying share has no value until you sell it. So options allow you to essentially defer the payment of taxes until you sell the share or the option. Restricted shares and restricted share units in an employment context will cause the income inclusion, i.e. the taxation, to occur immediately. That is the main reason we do options in Canada as opposed to restricted share units. Okay, so always exceptions to the rule. I'm giving you broad stroke advice here so that you can focus on the main points. We spoke about an equity incentive plan. I often get the question, how big should my equity pool be? Standard is normally 10 to 20%. And it's the board of directors of the company that decides this, not the officers or the CEO. Intellectual property. Everyone that is touching your company, this business that is developing anything, that giving ideas, that's an employee or consultant, should be signing an IP assignment agreement. Okay, always. The exception to this rule tends to be advisors. That can be more complicated. Usually they're not participating on IP creation. They are only helping with business strategy, helping with fundraising. So for them, that's less necessary. But for your consultants and your employees and your founders, they should always be transferring the IP ownership over to the company. And this is a crucial part. You can't fail on diligence with an investor on the IP piece. So that was it from me. We are, just to finish it off, we are a law firm in Canada that has a team focusing exclusively on emerging companies and startups. We do about 60% of the deal flow in the country when it comes to financing. Offices in Calgary, Vancouver, Toronto, Ottawa, and Montreal. So across the coast expertise. A small rep office in New York to do some work there, but really a Canadian business. So I'm gonna stop there. I hope I was able to kind of demystify a little bit incorporation and organization and the main things you have to be aware of when starting your business, which is essentially, you guys are going to own shares. How much should we allocate? Who's on our board? What's our vesting arrangements between us? Have I transferred the IP to the company? I would say those are the main ones that you have to be aware of. Okay. Now I'm going to leave it open. I took a little bit more time than expected, so I'm happy to stay a little bit longer if there are questions. And I leave it to you, Michael.
Well, thanks so much, Calvin. I thought that was really informative and helpful. I mean, as someone that once had a startup, I wish that I had benefited from a presentation like this before I started to incorporate and think of all of these aspects. So I know this will be useful for those who have attended as well as those who will be watching the recording. So at this point, we do have a little bit more time. If anyone does have any questions, you can feel free to pop them in the chat or raise your hand if you prefer to speak. And if any questions do come up outside of this, then you can certainly send them our way, and then we can maybe see if there's a way to get you some answers as well, especially for those who registered but weren't able to attend this webinar. So I'll just wait for another minute, see if a question does come in. But otherwise, I guess I would just ask Calvin, when it comes to any folks who are going to look to incorporate going forward. I know you mentioned that there's information online and they can already find. If they are looking for any other information that could help them or insights that maybe aren't readily available online, is there anything that Osler provides regarding that that can be shared with people?
Yeah, of course. So Osler is a national kind of leading firm in the practice area. What we do, the philosophy we've taken is we we grow with you. So we bootstrap with you. We're really there to help. So if you're looking for some additional help or guidance on, incorporation, we've prepared kind of guides to help you through that so that you don't really have to incur legal costs on that. You can kind of do it on your own. We also, once you start thinking of fundraising, or you really start thinking of giving equity, you need an equity incentive plan, you need to grant options. We prepared a very affordable package that we do for our startups that we actually defer the payment until essentially you get funding, whether grants or a financing round in. So we've really modeled our service offering and our practices to the actual needs of startups. So we can help you with that, the incorporation, the shareholders agreements, the equity incentive plans, the grants, the employment contracts, all of that we provide for you in the package, everything we think you are going to need based on our experience until your first equity financing round. And then we defer the fees until you are able to pay them, quite frankly, when you receive financing. So that's a really good question. And we're really open. We're in the ecosystem. We're a player there. And the idea for us is long-term business relationships, trusted ones that would go over time. Our success is essentially if the company succeeds. And that's a bit of the service offering we have in our business model.
Great. Well, that sounds like a fantastic model for startups. So I think we're pretty much out of time there. So thank you for those who attended, and we look forward to continuing this Essentials webinar series, and we'll provide information on other ones, including from Calvin's colleagues at Osler that will be coming up. So once again, Calvin, thanks so much for your time today, and we look forward to continuing to engage with you.
Thank you very much.